So, welcome everybody. How are you? My name is Rob D'Angelillo. I'm an attorney with Futterman Lanza. I'm 99% time I'm in the Garden City office. So glad everybody came out tonight. I'm going to talk just for a little bit about some estate planning, some issues, and also how it, works with, real estate and your homes and things like that. For most of my clients, their home is one of their biggest assets, or at least one of the biggest chunks of their, financial portfolio. So it's obviously very important to make sure that we've got it protected. And you might be saying, protected from what? I'm going to tell you, all right? So whenever I do estate planning, I always talk about the 4 basic documents, and most people are familiar with them a little bit. I say every adult should have a last will and testament, a power of attorney, a healthcare proxy, and a living will, okay? It bothers me that some of these terms sound familiar because there's a last will and testament, there's a living will, there's living trusts. So it does get confusing, and we try to help people work through it. So with the last will and testament, most people are familiar with that. It says, when I die, who gets my stuff? It also says how they get it. So if you're leaving something to somebody who's a grandchild or, a minor, somebody under a certain age, you might want to say, don't just give it to them, hold it in trust till they reach 25, 30. Money can always be used for health, education, welfare. The money can always be used, but it's in trust. So you don't have a 17-year-old getting this money and who knows what's going to happen. We also have provisions for people who have special needs, where we can say, all right, if I have a child or a grandchild, or in the future, if when they're to receive their money, if they're receiving government benefits, and by getting this money they're going to lose the benefits, we can say hold it in a trust. It can be used for everything but what the government benefits pay for. Those are just a couple of examples of what you do with the will. The next 3 documents I mentioned are while you're alive. So the first is a power of attorney. Power of attorney is the document that says, I'm giving somebody the ability to do anything that I can do legally and financially, okay? This becomes really important if, and I say God forbid a lot during my discussions, God forbid you become incapacitated and can't handle your own affairs. If that happens to you and you don't have a power of attorney in place, we're talking about doing something called a guardianship. A guardianship is a court proceeding. So you go to the Supreme Court next door if you're in Nassau County, and a family member or somebody that's involved with you who is trying to get that position says to the judge, Your Honor, this person can no longer understand the nature and consequences of their decisions, and we need them declared incapacitated, and we need a guardian appointed for them. It's a court proceeding. It takes time. There's a court evaluator that the judge appoints because the judge can't meet with everybody, and they do this evaluation. And by the way, they get paid from your money because that's how it's done. Once a guardian is appointed, every year they have to account to the court to say where all your money went. Every year you got to do an annual accounting. We can avoid that by doing a power of attorney. The other nice thing about a power of attorney is you're picking who you want to be your agent. So it's not, all right, well, this person, one of my kids wants to do it, but they're not really good with money and making decisions. I don't want them. So you get to pick who you want. So I always tell people that's probably one of the most important documents if you need it. And the last 2 of the 4 is a healthcare proxy and a living will. They kind of go together. So while the power of attorney covers all legal and financial matters, the healthcare proxy covers medical. So if you can't make your own medical decision, this gives somebody the power to make those decisions based on what your wishes are. So I always tell people, have that fun discussion with the person you name as your agent about, well, if this happens, this is what I want to have happen. It's only if you can't make the decision yourself. So the doctor's not going to say, Oh, Mary, do you want to do surgery or rehab? And they say, well, let's try rehab. They're not going to turn to the agent and go, well, what do you want us to do? They're going to, no. You make the decision. It's only if you can't, all right? And again, this avoids having to go to court and have a judge appointed for that. Have the judge appoint somebody for that. The living will backs up the healthcare proxy. So the healthcare proxy covers everything. Something simple like medicine A or medicine B, rehab, surgery, up to and including life-ending decision-making. But some hospitals, because of their policies, might say, all right, this person is, in a persistent vegetative state, but we don't know if you, as the agent, knew what their wishes are regarding artificial nutrition and hydration. The living will says that. So if you're in a persistent vegetative state, so brain's not working, it's not coming back. So it's not just a coma. People come out of comas all the time. This is what they call a persistent vegetative state. And you don't want the machines. That's what this declares. So when that hospital says, well, we don't know if you really knew, the agent pulls it out of their back pocket and says, no, this was their wishes.
Is that a separate document than the will?
A separate document. So these are 4 separate documents. This is the 4th. Yep. And I always tell clients, don't have your agent give it to the hospital right away, because I don't want them making the decision and trying to interpret what the document says. It's the agent making the decision and saying what they want, and this just backs it up if they're questioning what that person's wishes really were, okay? Now, I've had some people say, well, no, hook me up to car batteries, keep me going as long as, maybe they're gonna come out with a cure for being beheaded, I don't know. So if somebody says that's the way I feel, we can do a document that says, give me life support, keep me going. So it's what your wishes are. So those are the 4 basic documents. Beyond that, I'm gonna start talking about a couple of types of trusts, and that incorporates into how they work with the homes, all right? 5 years ago, if I had a client come in to me and we started talking about it, and they said, I've got 3 kids. When I pass away, I want everything to go equally to all 3 kids. Everything I own, my home is in New York, my accounts, everything's in New York. I would say, just do a will, no big deal. You're not cutting anybody out, nobody's fighting it, do a will, probate, no big deal. That has changed. It coincidentally was around COVID time that it started to change, but the courts are much slower now. I used to get, when everybody was in agreement, it was a simple will, simple estate. I used to get an executor appointed, 2.5 months was long. And then the executor can go and do whatever the instructions are in the will. Now, Queens is getting a little better. Suffolk and Nassau, frankly, are nightmares with the probate part. You file a petition, the court may not look at it for 7 months. So I had a client back in 2023, her mom passed in November, and she owned a home. And we submitted the petition probably in December. The court didn't look at it till July. So what does that mean? You have to keep property taxes. And property taxes, no big deal on Long Island, right? Yeah, it's a little bit of money. Property taxes they had to pay for like 8 months before they could sell the house. Homeowners insurance, you got to keep that on, God forbid, and constantly oversee the house. If there's nobody living in it anymore, you got to make sure that everything is okay. So there's all of those things. So one of the things to avoid that court proceeding, it's called probate, is you can put things into a trust. I'm going to talk about the revocable trust first, all right? The revocable trust, so you take the house that's in your name, all right, Mary and John Smith, and you're going to now retitle it. We do a new deed, and it's Mary and John Smith going to the Mary and John Smith Revocable Trust. The trust now says, upon both of us passing, and I'm just simplifying it obviously, my backup trustee, so it can be one of your kids, it could be a neighbor, a friend, family member, whoever you want, they're the trustee. You don't have to go through the court. You don't have to do any of that. and they can now sell the house right away. All right? So you have that flexibility. So the biggest thing that these trusts do is it avoids probate. Okay? When I sit with a client now, and again, back 5 years ago, when I used to say, oh, if everything was in New York, yeah, just do the will. Now I'm telling people to do the revocable trust. Back then, I would recommend revocable trusts if they had assets, homes, particularly in multiple states. So now you have a lot of people have a place in Florida, or they have a place in one of the Carolinas, very common. If you don't have a trust and have those both homes titled to the one trust, you have to do a probate in each state. So now if you have multiple properties in multiple states, yes?
What if it's outside of the country?
Then I would tell you, speak to an attorney in that country, because the way transfers of property work internationally can be different. And I tell them, if we'll work with that attorney if there's something they need us to do, but usually they're going to handle it separately. So with the multiple properties, I would say, yeah, definitely do the trust. That was almost a must. Also, if you are excluding somebody. So sometimes, I've been doing this for about 30 years, I've seen every kind of family dynamic you could imagine. People go, oh, it's estates, that's kind of boring stuff. I said, no, it's like family court, but somebody died. You have a lot of dynamics going on sometimes. Sometimes, obviously, it's all very smooth, but I've had situations where they say, you know what, I have this one child, I don't want to give them anything because of issues, blah, 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 blah. And I go, okay, let's do a trust, because by doing the probate through the will, I always say you're giving them like an invitation to challenge it. They either have to sign a waiver that they agree with the will, or they get served with a citation and they have to show up in court and say to the judge why. I'm actually testifying on Monday for a will I did in 2022 where one of the children isn't getting anything. It's all going to the wife, but the child wants to challenge the will. Now, I've done a couple thousand wills, and I do them the same way. So most of the testimony is going to be, it's the way I always do it. I do it this way, boom, 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 never change. So anyway, a revocable trust is a great idea. Now, it's not a big deal to put the house into the trust. If you're buying a new property, you can have the trust set up and just buy it have it titled right away. So it's a one-step process at closing. You don't have to put it in your name and then shift it to the trust. Okay, but again, the biggest thing is that it avoids probate. You have a lot of flexibility. And you also, with the trust, you can change the beneficiaries. With the revocable trust, no big deal. You have to come to the attorney, do an amendment to the trust, say, all right, instead of it going to 1, 2, 3, I'm going to go to A, B, C. But you can do that. So the revocable trust, total flexibility. The other trusts that we talk about is an irrevocable trust. So that's usually something that I recommend to when I have a client that's like 65 and up. So, I always say, you know what? If you're not planning on moving relatively soon and you're 70 years old, put your house in an irrevocable trust. The irrevocable trust, you cannot be your own trustee like you can in the revocable trust. The reason why we do the irrevocable trust is to protect your assets if you need long-term care. All right? So most people get long-term care one of three places. The extreme, and I know nobody wants to be in one, a nursing home. I get clients all the time when I'm doing planning. Well, I never want to go to a nursing home. And I go, there is nobody in the nursing home where that was the goal. They're not, high-fiving as they go through the door. But sometimes that's where the care need has to be met. Some people do assisted livings, and some people get care at home where they have aides come in to help them with the activities of daily living. So by putting it into an irrevocable trust, if you're applying to get the government assistance, Medicaid, okay, it's not in your name. So when Medicaid says you're only allowed to have a certain amount of things and amount of money, by doing that, you're removing it. Now, you might have heard about something called a look back, okay? The look back is when you apply for Medicaid and they say, all right, this is all you're allowed to have. And right now it's about $32,000. So you go, no, I'm good. I got $30,000. They go, that's great. But what did you give away in the last 5 years? So that's what the look back is. So what happens is they don't want somebody with $10 million going, oh, I feel like I might need a nursing home. I'm going to give it all to my kids. And then they go, yeah. You got that 5-year look back. I'm using round numbers. For every $15,000 you gave away during that 5 years, it's a 1-month penalty. So if you gave away $300,000, for the first 20 months, Medicaid's not paying. They go, you had it, you gave it away. Now, if it's 5 years and a day, that's off the radar. So we tell people, put your home into an irrevocable trust. It's a biggest asset, gets it out of your name, and it starts that 5-year clock ticking. All right, 5 years later, it's not considered for Medicaid. Home care Medicaid today doesn't have a look back. So if somebody walks in my office today and says, we need care for mom. We want to get some care in the home. We want to have Medicaid help us pay for AIDS. We could transfer everything out of mom's name today. And August 1st, she's eligible. But that is going to change. We're not sure exactly when, okay? So in 2020, October 2020, New York signed into law a 30-month or 2.5-year look back for home care Medicaid. Because COVID was going on then, the federal government said to the states, you can't change how you apply your rules. So you can't now put a look back in. But the COVID emergency is over, so they can. So we don't know exactly when it's going to go. Right now, they're still inundated from all the work that built up during COVID. They didn't do a lot of recertifications. I heard a rumor that it's going to happen in September. I'm not really sure. Might be the beginning of next year. But when it happens, there will be a 2.5-year look back. So we tell people, even if you say you're never going to go to a nursing home, if you want care at home, we are going to have a 2.5-year look back. We got to start that clock ticking. All right. When you put your home into an irrevocable trust, only 2 things change. Okay, remember I said you can't be your own trustee, because Medicaid looks at it and they go, if you're the trustee, you can do whatever you want. You got control. Take the house and sell it and you get a pile of money. So you pick somebody. The one thing is, if you want to sell the house, you need your trustee to go along with you. Okay, so the trustee has to agree. And some people go, what if the trustee doesn't? So if the trustee is also a beneficiary in your irrevocable trust, you can change your beneficiaries. So if you say to your son, oh, look, I want to sell the house. And he goes, no, I like this house. Sorry, not going to sell it. You can say, I'm going to call Rob and I'm going to change the trust. So when I die, you get nothing. And then he goes, oh, I'm sorry. What do you need me to do? Yeah, we can sell it. No problem. All right. So you just can't sell it on your own. All right. When it's sold, the money goes into the trust. And if you're downsizing, the trust can purchase the new place in the name. You keep that keep that clock ticking. If it's after 5 years, it's off the radar, you're good. The second thing, yes. So I said there's 2 things that change. One, if you want to sell it, you need your trustee. The second one is, generally speaking, no new mortgages, okay? So you're not going to be able to get a home equity loan or a home equity line of credit. I had one bank tell me that they could do it. I haven't seen it happen yet, but 95% of the banks, once it's in the irrevocable trust, they won't give you a home equity loan or something like that, a new mortgage. And some people say, well, again, this is getting into the nitty gritty. Some people say, well, if I have a mortgage and I change the deed, can't the bank call the loan due? Because there's something called an acceleration clause. There's federal law that doesn't let them do that. So we're okay. So those are the only 2 things that change. One of the very important things is property tax exemptions. So if you have a STAR exemption, sometimes the seniors have the enhanced STAR. Sometimes veterans have veterans exemptions. The way these trusts are written, you still keep your property tax exemption. So I tell people, if you get a letter from the town, don't call the town, call me. I send them the pages and they go, okay, we didn't know. Also, step up in basis. I get them a little technical, but I get some clients where they paid $30,000 for their house when they bought it. Now it's worth $700,000. So there's that big capital gain. You still get the step up in basis. So when you die, whatever it's worth when you die and it passes to your kids, That's what their cost basis is. So all the taxes stay the same. So all the good stuff stays the same. So to me, a house is kind of a no-brainer when you're 70 and you're not planning on selling it. If you're planning on selling it within 6 months, do that, and then we'll put the new one in when you do it. The last thing I want to talk about in terms of owning it and estate planning is there is something that came into play last year. It's a beneficiary deed. So we used to do this thing back in the day. You can still do it prior to 2005, where we did something called, and you might have heard about it, a deed with a life estate. So a parent would put their children's names on the deed, and the parent would retain something called a life estate, where it says, during my life, I can live in this house, you kids get out, I can kick everybody out, but when I die, it automatically goes to the kids. We used to do that as a Medicaid planning tool, because even though we had the trusts back then, it was only 3-year look back for doing the deed with a life estate. It was 5 years for trusts. In 2005, with the Deficit Reduction Act, they changed it so everything is a 5-year look back, even that deed with a life estate. The reason why the trust is better, and again, I'm getting into the weeds on this stuff, is with the deed with a life estate, once you put your kids' names on the deed with a life estate, you can't change that, okay? And I have a situation right now where somebody passed away, their parent, their mom, put their name as a remainder interest. Now we had to do this whole thing about what's going to happen to that share when it gets it. So it's a whole complicated thing. So, and also if you sold the house, some of the money came back to mom. And if we're trying to plan for Medicaid, we don't want that to happen. So now we rarely do that. But new thing is they have something called a beneficiary deed. So you can say, all right, I'm going to put my kids as beneficiaries so that when I die, it goes right to them. I don't really recommend that. It's cheaper than doing the irrevocable trust, but because one of the problems is you can change the beneficiaries. That's the good thing, okay? But the problem is once you pass away, now you've got 2 or 3 kids maybe on the deed, and one wants to sell it, the other one doesn't, they start fighting. When it's in the trust, trustee can sell it, get the money, distribute out the money. They're not negotiating with the other beneficiaries. So that's basically the reason. And it doesn't really give you, and it doesn't give you any protection for Medicaid, the beneficiary deed. So that's basically it. If anybody has any quick questions, otherwise I'll be, when we're done, I'll be happy to answer any questions. I'll speak to you afterwards. All right. So we've got Mark Richter, whose idea was setting this all up. He's going to come and he's going to talk to you about your wonderful homes and all that good stuff.
All right, thank you, Robert. So if you guys own a home, there's a good chance you've received about 1,000 postcards in the mail from brokers, just sold on your block, just listed on your block. We have buyers for your property. So this isn't that. I'm not here to pitch you guys tonight, just to give you some actual information that you can use before you really ever decide to sell. So I saw some laughs. I'm sure you guys did get those postcards. By the way, if some of them were from me, I apologize. But like Robert said, here's what we see happen. A family decides it's time to sell mom or dad's home. And that's when they discover that the extension that they did in the backyard was never permitted, or the sign-off was never done. Or a house that they thought was always a 2-family house actually has a certificate of occupancy for a single-family house. So that's where we come in. My name is Mark Richter. I'm with Commerce Realty Group. We're based out of Queens, and we specialize in selling homes in the 5 boroughs of New York City, with a particular focus on properties that have been in the family for many years. And these properties are not, I guess what you'd say, cookie cutter listings. It's important to get out in front of any potential issues. And that's why tonight I want to just give you guys 3 key points to consider before you ever decide to sell the house. And the first one is get out in front of issues early. So like I briefly mentioned about open violations or permits, you don't want to be that seller 2 weeks before the closing. You have all your stuff packed up, you have the new house ready to go, you have the date circled on the calendar, and we get a call from the buyer's bank saying that they can't fund the loan because of a violation from 1991. Or, like I mentioned with the certificate of occupancy issues. What a lot of brokers won't tell you about real estate is that just as important as finding a buyer, it's making sure that all the paperwork lines up behind the scenes so that when that buyer comes, you're actually able to get them to the closing table. So the first thing I'd recommend is know what's going on behind the scenes with your property. If you don't know the paperwork behind it, we're happy to run a report for you. We can go over each open item and come up with a strategy together to make sure that all and any open items are closed out. So when the time comes to sell, you're in a position that you're able to get to the closing table. The second thing that we find important and a lot of our clients like to know is that you have more flexibility than you think. We hear this all the time. I want to buy, I want to sell, but I need to buy something first, or should I buy it and then sell? So there are things that you can work into the contract. These are valid concerns, but there are ways to address them. And one thing that our clients like to take advantage of is something called post-closing possession. This is where you're able to sell the house, collect the majority of the proceeds from the sale, but stay in your house for an additional period of time. Usually it's about 30 to 60 days. But that allows you to collect the proceeds from the sale and use it to buy a new house while staying in the original property. So you're able to do that to line things up in terms of a purchase, and it gives you a little bit of an extra window after the closing. The other way is to extend the closing. So if you know that you have a buyer lined up, you want them to buy the house at this price, you want to take advantage of the market, the neighbor wants to make you an offer that's, you're too good to pass up, but you're not ready to move for 6 months or a year, you're able to work that into the contract. So you have the buyer lined up, you have him committed under contract to pay you a certain price, but you don't close until you're ready to move. So it gives you that peace of mind to know that you have the buyer in place. It gives you the financial flexibility to understand exactly how much you're going to be making on a sale, but it gives you the leeway to be able to leave and move out when you're ready. We just had a client in Flushing on Utopia Parkway. I guess it was in April. He closed in May. He didn't end up moving out of the house until the end of, let's say, July, and he kept his garage for another month after that. So he needed an extra 60 days to get the stuff out of the house. He moved it into the garage, got another 30 days in the garage, and then was able to finally leave. But he had gotten the proceeds from the sale, and he was able to purchase his new house. So that would be the second thing. You have more flexibility. And lastly, the third one, which is probably the most important and may seem like the most obvious, but unfortunately is not, is know what your house is actually worth. And that doesn't mean go on Zillow and look at the Zestimate. And that doesn't mean go on one of these websites and put in your address and get a algorithm of what they think the house is worth, even though they're based nowhere near New York. And it doesn't mean calling that investor who sent you that flyer and everyone else on the block, I'll buy your house all cash tomorrow. I'm sure you guys have gotten those. I'm talking about a professional report from someone in your market who understands what properties like yours are selling for in your area. Now, even if you're not looking to sell, this is something that's beneficial to know. We check our stock portfolio, I'd say multiple times a day, definitely multiple times a week. It definitely doesn't hurt to check the value of your house every couple of months. So just to know the financial wherewithal that you have in your asset, I'd say that's something that does not hurt. But there's some other benefits of knowing the value of your property as well. Maybe there's a minor touch-up or a small improvement that you can do that would drastically increase the price of the property when you do decide to sell. So by having that knowledge, hey, maybe if it's something as small as, throwing out the garbage in the basement or, adding a window here, something small, but that can really increase the value, that's a good thing to know in advance. It could also be the flip side. A project that you think you're going to do to increase the value of the property, but really, that's not really what buyers are looking for in the market right now, and it won't really bring you that return that you think you're going to be getting. Maybe it's something to hold off on, save the money, and still be able to get the value that's in the house to begin with. So we're happy to run a free report for you to show you, what homes are selling for, to give you an idea of some improvements you should or shouldn't make, and to give you an idea of really where your asset stands. Everybody in this room, whether it be, in a month, in a year, in 2 years, in 5 years, in 10 years, are going to be faced with the question, what are we going to do with the house? And Robert went over different things and how that plays into it. But we're also here to help provide stability and clarity to this question that is a big question, and it's an overwhelming one at times. And with the right knowledge in advance, when you do make that decision, you're able to come to the market from a position of strength and clarity as opposed to stress and confusion. So I want to thank Robert and Futterman Lanza for hosting us tonight. If you guys have any questions you want to ask both of us, we can do that now. If there's something privately you want to discuss, we're here as well. And most importantly, thank you for taking the time out of your days and coming in and hearing us tonight.